Hey, good morning, Smooth Operators. This is Raymond DeLeon with Smoothoperationoflaw, and today we're going to talk about what is the difference between mediation and arbitration. All right, so look, a lot of times people have contract agreements or they're going through child support. They might be going through divorce, maybe alimony settlements. They might have some form of dispute between another party, and you guys are trying to bypass going into some sort of major lawsuit or major jury trial, and you want to have a form of alternative dispute resolution. Well, there are two methods for that, okay? Those two methods are mediation and arbitration. Mediation is where the parties to a dispute retain the right to decide whether or not to agree to a settlement. The mediator has no power to impose a resolution other than the power of persuasion. All settlements reached at the arbitration through mediation are memorialized in a written settlement agreement. Mediation is appropriate when the parties are having difficulty resolving the dispute because of lack of conflict resolution skills or because of resistance to confronting or being confronted by the other party. The mediation can help by clarifying productive steps to problem solving and by providing a neutral, non-threatening environment for discussion. So you might have, an argument with the other party. Or you might tend to argue with the other party because you guys can't see eye to eye. A mediator would be useful to come in between, sit you two down, and say, hey, look, man, no cursing, no screaming, no freaking violence, no anything like that. Why don't we reach a settlement, okay? We'll draft up the contract, and then we'll give this to an arbitrator, and the arbitrator will take it. And based on what we agree to here and the nature of the dispute, they will make a streamlined, more fast, less expensive, more effective way of reorganizing the situation in such a way where both parties can leave happy. Now, arbitration, on the other hand, is different. Okay? Arbitration, and this is my opinion, arbitration is like a closet knife fight. And I'm going to tell you what I mean by a closet knife fight. Arbitration is where the parties give the power to decide the dispute to the arbitrator. Evidence and argument is considered and a written arbitration word is issued. The process can be formal or informal as the parties desire. Arbitration is a binding or non-binding process where an arbitrator, rather than a judge or jury, applies the law to the facts of the case and issues an award. What's the difference between binding and non-binding? Binding arbitration means that the parties waive their right to a trial and agree to accept the arbitrator's decision as final. Generally, there's no right to appeal an arbitrator's decision. Non-binding arbitration means that the parties are free to request a trial if they do not accept the arbitrator's decision. So, arbitration is also a form of alternative dispute resolution. An alternative dispute resolution, again, is that you're not going to have some long, big old trial where, you're going to have a whole jury. It's not going to be expensive. What you're really trying to do in arbitration is you're trying to come with a faster resolution. But here's the difference. And this is why I say it's a closet knife fight. Because usually arbitration can only take place where there is already an established agreement and an established form of resolution agreed upon between the parties prior to going into that venue. So with arbitration, okay, you've already done pretty much an act of mediation, and you did it through foreseeing the possibility of some sort of default. In more simple terms, arbitration comes from a contract or an agreement. So all those little details about what would happen in the event of, and if the event does occur, where there is a breach or a default, that's already decided because someone was smart enough to say, hey, if you don't complete this by this day, binding arbitration. We go directly to arbitration. So why is it a closet? Because it pretty much encloses all possible outcomes. Why is it a knife fight? Because you can't run from it. The minute that you have an arbitration clause in your contract. A civil court cannot hear the case unless both parties fail to enforce their arbitration agreement. Let's say I have a mortgage and I'm sitting there and I'm like, hey, you know what? Binding arbitration in the event that you fail to pay. And you sign and you get your loan. And then you try to go into court and say, hey, you know what? This contract is jacked up. I found some illegalities in it. Right? Some illegalities. The defending party, meaning me as the bank, I can sit there and go, hold up, this is the wrong venue for this. Any disputes regarding the matter should go to arbitration. And then I'll show a copy of the contract, and then I'll put in a motion for removal to the appropriate jurisdiction and venue, and you ain't going to be able to bring up any of those bullshit little fucking inquiries that you might want the court to address. Okay? So in arbitration, then we'll talk about arbitrability and other topics that I'm not going to get into right now because it would be too in-depth and too crazy. Personally, I love arbitration because in arbitration, you can write a contract that is borderline bullshit, but at the same time, legitimate enough that it would be legally binding. Let me give you an example. You know, Stormy Daniels, Donald Trump. Stormy Daniels was saying, hey, this contract violates my rights when she had sex with him and, you know, she wasn't supposed to speak on it because she had an NDA in that agreement. It was a non-disclosure agreement. Donald Trump paid her $150,000 to keep her mouth shut. She chose to try to make a spectacle of it. Next thing you know, Donald Trump's team was like, hey, there's an arbitration clause. She's like, no, I got a First Amendment. He's like, no, you signed a contract because there's a non-disclosure agreement inside of that contract. And it's not supposed to be handled here. And she ended up having to pay him $350,000 to keep her mouth shut. And there was no First Amendment anything because she was in breach of the very clauses in that contract. And since she accepted the $150,000 consideration, she was bound to the duties imposed on that contract. So that's why I like arbitration. Now, there are different ways that arbitration can occur. Okay? Arbitration can occur with a signatory, or you can even bind a non-signatory, depending on certain criteria that can be met. Donald Trump did not sign the contract when he gave the $150,000, but his intent was clear and unequivocal by his actions. He gave the $150,000, which means I'm with it. The attorney actually, on his behalf, set it all up and paid her out. So he didn't necessarily have a direct hand in it. There was a fund that paid Stormy Daniels. So could Donald Trump could Donald Trump had pulled himself out of that agreement by saying, no, that attorney did X, Y, Z on my behalf. I never signed. And why are you touching that money that was in that fund in order to pay Stormy Daniels? Maybe he could have. But Stormy Daniels had signed it and accepted the money. So when she breached it, she was stuffed into that closet. And when she tried to get out, she ended up having to pay him $350,000 and absolutely got liquidated by that ink stick knife. So it's a knife fight in a closet. In arbitration, you have to remember there must be an already established agreement. In mediation, you are trying to come up with some form of agreement so that you can hand the matter over to an arbitrator to see that they look at your agreement, acknowledge it, and then they'll put a court seal on it, making it legally enforceable. Both an arbitration agreement that is binding and An arbitration agreement that is non-binding are both legally enforceable. The non-binding portion is just that if you don't like what the arbitrator did in that tribunal, you actually have an appeal mechanism, and you could take it to, a civil court and actually have the judgment overturned or go through the tribunal's appeal mechanism. Arbitration and mediation, again, are just alternative dispute resolution tools. They make it easier on the parties by expediting the resolution, and once the resolution is expedited, the benefits can be that 1, you actually have a resolution, 2, that it costs a lot less, and 3, that it's based more on the facts of what had happened rather than, some open courtrooms where they politicize things. Or they might, the court might just not like you. You might end up in a civil court where you've sued a bunch of people, maybe some government officials, and in that open venue, they don't like you. So they might judge against you because it's civil. There's no contract, and so they will apply the law with their discretion and as they see fit, as opposed to trying to stick to some sort of parameters of a script. The parameters of that contract are known as the four corners doctrine. And that means what is inside that paper are the terms and conditions, and anything outside the terms and conditions of that paper is considered outside evidence or parole evidence. And you might want to look that up. And parole evidence just so happens to be all evidences that are trying to contextualize the terms of what's on those parole evidence is what is the outside evidence that an individual may present into a court in order to contextualize what is inside of the agreement or what's written down. So it's kind of cool to have agreements prior to doing business with somebody. Now, everybody wants to know, can you arbitrate a public official? Yes, of course you can. Every time that there's a Title 42, Section 1983 case for a deprivation of rights under color law, i.e. some sort of constitutional violation that has been committed by a public official and a party sues them, every time you have one of those scenarios, the first thing that, if the state finds that they may lose, the first thing that they do is they try to settle. So instead of having to pay you the $5 million for the offense, they try to resolve the matter quickly. Like, hey, man, we'll give you $50,000. And then you'll get a settlement agreement and a release. So they do that. A lot of businesses do it, too. And a lot of times when you're doing business with a government agency, there will be mediation and arbitration clauses in your contract. So yes, you can do it to a public official. Is there a way to use arbitration to absolutely obliterate a judge who is disregarding your complaints, disregarding whatever you're saying on a case, disregarding your motions, and you might be presenting fact? The answer is no. Not you can't. You can't just arbitrate them because you have no agreement with them outside of the social compact. And they have an obligation to the court, not to you. They have an obligation to the court. Remember that, to the court. So they're going to do what they see fit best in the interest of justice, and discretion is a motherfucker. And they have judicial immunity. So the smooth operational law and our operators operate in such a way where we can bypass that? Yes. And we know how to bypass that. And the way that we bypass that, I'm not going to say right here. But there is a way to have a judge based on the example that I gave you with Stormy Daniels and Donald Trump and that whole scenario. If you look at the schematics of that, there is a way to actually bind a judge. You won't be able to do it personally, but if you look at my other videos and you look at that trademark, and they use that trademark, and they have acceptance of using that trademark, and you can put an arbitration clause maybe in a cease and desist in which you mail to them, yes, they can, because the trademark is a form of payment. And then you can set up your terms and conditions inside of your cease and desist and turn that cease and desist into a cease and desist agreement to arbitrate. I'm going to stop right there. But if you understand what I just said, then you can kind of see how maybe you could bind a non-signatory to end up in a situation where they might have not been ready for, just off the fact that they violated your trademark and they're getting paid by public funding, which means that it's a transaction that they're conducting the minute that they're employed. And as an employee of that state, they're acting as an agent to do a trademark infringement, i.e. trademark theft, because they might not know that although they're talking to you directly in that courtroom, the asset on their documents and the bonds that they have and all that money that they're making is actually tied to a commercial asset that's owned by another. And since they are not an offending party, and when I mean another, I mean your trust actually owns the name, they might be looking at you, but they're using your trust's asset. And upon using your trust's asset, it is a Fourth Amendment violation because intellectual property is a property. And there's a confusion in the courtroom. And so it looks like that judge just stole from a trust who is a non-offending party, non-party to the case. They just stole their asset, commercial asset. And since it's a commercial asset, it creates commerce. And since it's commerce and they're getting paid, they are monetizing or doing a conversion on that asset that they took in the violation of a Fourth Amendment, of a violation of the Fourth Amendment, wittingly or unwittingly. And if you ever looked up the definition of operation of law is where the debt or a liability occurs regardless of the intent of the parties. And you can put that into Wikipedia. And it'll be the first sentence. So if you've been listening to this entire video and have been tracking what I've been saying with my defragmented sentence structures, because I'm thinking in real time and doing 99% of this off the top of my head, trying to explain it while recording, then maybe you can piece together a scope of view of how to do a collateral attack on a courtroom, whether they were ready for it or not, and you will have a high success rate. And when I mean high success rate, I mean close to 100% of the time. They're applying law, you are applying law. Arbitration is a closet knife fight. It's based on an agreement. When you go directly to arbitration, there's no need to mediate because you guys have already agreed. Trademark your name and it's a commercial asset, and anybody that touches that is now conducting commerce and therefore waives their state immunity, sovereign immunity, qualified immunity, or any other type of immunity. So I hope you enjoyed today's arbitration versus mediation. I like to arbitrate. I don't need to go into a courtroom and civilly discuss anything when I can flank the situation with a trademark claim because of the nature of the court making money off of trademark infringement, whether they knew it wittingly or unwittingly. Have a good day. Like I said, it's Raymond De Leon with Smoothoperationoflaw. And hey, smooth operators, hit me up on Messenger, on Facebook, and let me know what you think. Or in the comment section below, go ahead and let me know what you think. Good day.